just want to formally introduce Andrew. Andrew has been with us about 20 years back for a year here, 1 year, working with us. In fact, he stimulated the formation of a formal skull-based surgical unit. He was a renowned skull-based surgeon. He came in a voluntary sort of basis to come here and work here. And that's how our skull-based surgery program got into offing. Now he has relocated from US to Europe, and then he was quite keen to come here. He came here for our 20th anniversary celebrations, and then he was very keen to come back and spend some time with us every year for some time. So this is his first visit in that lab. He is here with us for a month. Andrew is one of internationally renowned skull-based surgeons. More than that, he has in-depth knowledge of lot of things, which the moment you spend time with him, you come to know his knowledge of history. He says that he has read how many hours? Every month he reads about, in his driving, he reads with the new PDF readers, which is the thing, hours and hours. So he gave me a lecture of what is happening in Eastern Europe and Serbia. Yesterday when I saw the TV, I could really understand what is happening between Zelensky and Putin and this one. Talking to him, that's the way he talks. And he has a tremendous sort of interest in AI, and then this topic he chose, that AI is coming up so much, but nobody thinks about ethics and legal implications in medical field. So that's what he's going to talk to us about.
Great. Thank you. So, just before I take this off the screen, if you scan this PDF on your phone, you can download the whole PDF of the presentation. So, last takers to scan, and then I will turn to the presentation slide. I see a few more scanners. Okay, because this topic is extremely complicated, and I'm going to take this down now. Sorry, here, and let's go now to presentation mode and go to widescreen. Hold on. Okay, so this topic, as I've been preparing a journal article on it for one of the AI and biotechnology journals, is extremely complicated, and it's really new. By doing a literature review, there are only a few articles in the literature that even discuss this. And the majority of the articles are published in law reviews. And law reviews, unlike what we like to read in medical literature, has no pictures, only words, paragraphs and paragraphs of words. And a lot of the articles that are in the medical or the scientific literature, they basically have the same theme, that this is a new and very confusing situation. And I agree, it's very confusing. And I'm not going to pretend to be able to explain very clearly exactly what's going on with this. But what I intend to do is to go through some basic examples of different scenarios about AI and its use in healthcare. And then I will show you predominantly US-based case law principles, because the US-based case law is really the framework upon which most other nations have built their case law system. In the European Union, there is also a case law system, and we'll talk about that a little bit also. But it's related to it. It's a little bit different related. And I'm sure that in India, your case law system is also related to these systems. Now, again, that could be a very interesting topic for yet another research review paper, is to look specifically at case law in different countries, in India, for example, and that's something we can talk about doing in the future. But let's just begin and just point out that what we're going to do is we're going to look at artificial intelligence as a new entity that's entered the healthcare field. And to give an example, just a concrete example, imagine a scenario. A doctor has statistics, and more and more statistics are being kept on clinicians in groups, and then more and more as a lot of payers in the US are going towards these quality metrics payment systems, there will be more and more statistics kept on individual doctors as well. So let's say that you know that your probability of having a correct diagnosis on a particular kind of problem is 95%. It's a bit of an abstract concept, but it's realistic. Let's then assume that your hospital has offered you an AI system as well to help with these diagnoses, and the AI system is rated at 98% efficacy. So you go to your AI system and you enter the question about the patient's data, etc., to the best of your ability, and it comes up with a recommendation and you don't agree with it. So you have a bit of a conflict. What should I do? And this is a problem that is going to face all of us, and it is already facing all of us, and it has happened, and I'll show you some examples of how this has been handled in previous case law examples. So, if you decide not to listen to it because you feel you're in your instinct that you have a better understanding, statistically you're going to be 95% correct, but the AI, which you think is wrong, has a statistical probability of being 98% correct. So it leads to a lot of confusion of what you should do. And even the courts have been divided on what you should do. Okay? Should you listen to it? Should you not listen to it? This is a big dilemma that we never thought of before. But the closest thing that we do have to this today, which we deal with all the time, is clinical guidelines. So we often have clinical guidelines, but we don't always follow clinical guidelines, right? So, the position that a lot of these articles are taking, give me 1 second, I'm going to try to fix this from not disappearing because it'll be annoying. I have to just set the settings so that it doesn't go away. Let's see. Screensaver. I don't know. I know how to do it on my iPhone, but I don't know how to do it here. So we'll just have to deal with it. Sorry. Okay. So, we deal with this today. Now let's go on now and let's look at what is AI. AI is basically any kind of process, computer, robotic, anything that is tasked with doing something that a human intelligence would otherwise be capable of doing. But the presumption is the software is allowing us to do it in a better or faster way, encompassing a lot of data that the human brain wouldn't be possible to calculate and compute all of this. So that's the principle behind AI. And AI relies heavily on the concept of heuristics. And what is heuristics? Heuristic is a shortcut, a rule of thumb. It's a principle, it's a strategy. It's applied in algorithms. It's basically some decision-making tree that doesn't rely on actual statistic or set rules. It's a guess based on different things like probabilities and balancing probabilities, and we think heuristically all the time. What makes AI different from other types of software is that it implies that heuristics are used heavily, and they're actually programmed into it to allow the software to make its own decisions. And the more complex, the deeper the heuristics are in the software, the less obvious it is to the user, even to the developer, right? So that the system is programmed to learn itself through usually types of probability statistical balancing. And that's how AI operates. Now, machine learning is basically the overall characteristic or the term that's used. And machine learning can be very rule or structured data, but what makes machine learning significant is that the machine itself is training itself, right? So that's the machine learning concept. And then there's another term that you'll see in the literature called deep learning. And the deep learning basically is building many, many layers of algorithms deeper and deeper, and it's growing. It's doing it itself. So at some point, the developer or the user has no capability to actually track exactly why an answer was given. And that brings up, that's the primary reason why there's such a dilemma in terms of liability. Because, and we'll get through this a little later, but causation is a concept in the courts that a plaintiff who brings a complaint about a harm or an injury has to prove causation. And causation is usually dependent upon scrutinizing some process and seeing this is what happened and this is what was wrong. But when we have a deep learning system that even the developers or the programmers are unable to determine that, causation may be very challenging. That's the primary dilemma that AI is giving to the legal implications of its use in healthcare. Now, there are different kinds of AI systems, and you'll see these terms, and you have to understand them, especially if you're either asked to use one or you're working in a setting where you're in the hospital administration and you're licensing or purchasing an AI system. There are fixed models or locked models, and then there are self-learning adaptive models. Now, the fixed locked models are treated much more like a product because you're able to see it exactly what it was supposed to do at the time, and all of the pre-certifications and everything is fixed, and it is as it is. Okay, so this follows a more traditional product liability pathway in the courts, and I'll explain what that means. But a self-learning adaptive model is constantly evolving with the new patient information that it's receiving while it's being used. So this puts a lot more burden upon the manufacturer, the clinical users, the healthcare institution that licensed or purchased it, because it's no longer the same as when it was bought. Okay, so that has very significant legal ramifications for fault when it makes a mistake. Now, you will also see in the literature these black box, this term black box. This is the most common term that you'll see, and it really means it's the most opaque, the least transparent, and it's nearly impossible to trace its decision making. That's the most problematic AI system. A white box is fully transparent. It's like an electronic medical record that just gives and flags certain warnings about drugs, strictly off of just checking something clearly off of a database. And gray box are the things that come somewhere in between. They may use a little bit of probability, statistical analysis, but still they may be able to be traced, but not quite as able to be in the black box. And the black box is what we're really concerned about. Now, give you examples. A white box, an EHR that just says, okay, there's some drug interactions, it has very clear defined rules. The gray box, there's a sepsis early warning score, and it's relatively interpretable, but it's following some kind of probability model that may be a little complex to actually track, but with some effort it may be done. Another example with the imaging is if an AI imaging software just generates heat maps or areas of concern, but then lets the clinician determine what's going on in those areas, this is in a gray box because it may not be exactly clear why these areas were highlighted, but it didn't make a diagnosis. It just gave you some additional information. Black box, let's say there's a deep learning sepsis predictor. You cannot verify exactly what the parameters were. Now there are tests, there are statistical tests and other kinds of models that can then go back and try to explain why the conclusion was reached, but they're only approximations. So they do not precisely pinpoint exactly where a significant error or a misdirection occurred. And that's a problem, as I mentioned before, in the causation element of legal cases, because it's very difficult for the plaintiff to pin down exactly causation and link it to the harm, which is a prerequisite for recovering damages in a legal case. Here's another example of a black box, a CT brain hemorrhage detector, and it just simply puts out a yes and no. Okay, that's a fully black box, and it's also linked to a more what's called autonomous system, where it just independently comes with an answer rather than giving some helping advice. Okay? Again, I think I mentioned this, the autonomous versus the non-autonomous. Why is that important? Now, autonomous, it puts the liability more towards a product liability, which implies something a little bit abstract, but you have to think of it this way. Okay, I'll explain that in a minute. So autonomous acts more like product liability, and non-autonomous acts more like a negligence situation. So what's the difference? Product liability is looking for a specific defect, and it puts more burden on the manufacturer, while non-autonomous systems actually put more burden on the clinician. However, negligence is harder to prove than defect, because negligence, so this is more difficult to get a positive outcome for a plaintiff in a lawsuit, because they have to not only show that there was a causation and a direct relationship to the injury, but they have to show that something was negligently done, basically. While product liability, often called strict product liability, puts the burden more on the developer, and if a specific defect can be claimed, it's a little easier to get a judgment against the product. Right? So autonomous systems are a little riskier in a sense than non-autonomous systems, also because they don't have human input in the final decision, and it shifts the liability here to either the producer or the hospital system that decided to buy the system, right? And all of this depends ultimately on what the protocol in the hospitals are, the policies. You know, we may find ourselves one day when, 1,000 reports are made by a radiology system, and that one radiology doctor has to come and sign them off. So is he responsible for the mistakes that it made? Is the company responsible for the mistakes that were made? Is the hospital responsible for asking a physician to approve 1,000 CT reports in a day? it's not unreasonable that that may happen. You know, we already are signing off just based on our license for a lot of things that go on around us that we have very little control over. All right, so this dilemma is not new to us, but AI makes it more likely to become a problem. Okay, so what ends up happening is that we end up with this complex web of contractual relationships between the developer, the manufacturer, the vendor, the hospital, the clinician, and a lot of this falls into this situation, duty to the purchaser. So there is in liability, in product liability, there is this concept of duty to the purchaser or to the user to inform what the risks are. But then, does that duty transfer to the patient? It's unclear. So if a patient or a plaintiff is pursuing a manufacturer or a vendor, it may be very difficult because they may be able to put the blame directly on the purchaser, stating that they were informed about the probabilities of these errors, or the user, that they were informed. And you see there's an intricate chain of liability responsibility, and this is an increasingly problematic challenge for the courts, because the courts still have a very clear-cut definition of what constitutes either a product liability fault, a defect, or a negligent fault. So the other thing that comes into play is, what's the origin of the system? The overwhelming majority of AI systems trained on patient data in the United States come from one or two major academic centers in Massachusetts. Now, what happens when that system is developed in-house by the hospital under some kind of research collaboration? It's more likely in that scenario that the hospital itself may bear the burden of the liability of the performance of that system. While if this system is then sold or licensed to other systems throughout the world, it'll shift the responsibility to the vendor. But the data can be trained on, usually from internal data sets from the hospital, and this brings up very significant issues regarding privacy laws. So let's say this Mass General Hospital has all of its patients, and it trains it on the data set, and it does statistical analyses, and it shows that it's 99% correct. And that's great, until you move it to Amrita Hospital, and you have a completely different patient population. So this becomes yet another factor to be looked at in a specific product liability or even a negligent case, because in product liability defect, it may be not so easy to prove that the system didn't work, but it could be viewed as negligent on the part of the using institution or the vendor not to have updated the data to a local environment. See? So these things can be judged in different ways, depending specifically on how the lawyers for the plaintiff frame the question to the court. So that's one of the reasons why this is being viewed right now in the legal world as problematic. Okay? So on an aside, then we have to ask ourselves, is it problematic because it's problematic to the lawyers? Or is it problematic to the doctors? There are different kinds of problems depending on the perspective, right? So if you're a plaintiff's attorney, you would like the system to be as clear and crisp and simple as possible. If you're the courts, you would also like that because it's expensive to try cases. And the longer and the more experts that are required, the more burden on the legal system. But if you're a clinician or a hospital, you wouldn't want it to be so easy to find judgments against you. You want to, we live in that world now anyway. I mean, the statistics are that over 90% of really what could be considered negligent events are not tried or not even noticed in courts. It's only a very small percentage that actually makes it into the legal system at all. Because as we all know as doctors, things happen. I mean, there's complications and we make mistakes. Now, there's no way to avoid that. It's gonna happen. The thing that's concerning to many of the people starting to explore this dilemma is that it might become easier and easier to bring the problems to the courts because they might be very easy to just point a finger. If your doctor followed some recommendation and the recommendation was wrong and you were injured, now people will become aware that there's some AI that made a mistake. And this brings up yet another dilemma where traditionally in courts, in the US particularly, the target of plaintiff complaints usually goes towards the clinician. And the clinician is covered by a limited amount of insurance. There's sort of a cap on that. In some states, there's a cap on what you can claim for medical negligence, while there may not be a cap for general negligence, right? So there's protections. But if the claims start to shift more towards the hospital that purchased the system or the developers of the systems, which will be multi-billion-dollar corporations putting these out as things, keep going in the world the way things are going, they will have deeper pockets. So the legal system tends to go after the deeper pockets, and this kind of situation it just places a deep pocket into the chain of healthcare when it's used. And this could be a real problem moving into the future. Now, this is the most important thing to understand, traditional tort law basics. This is the US-based system. The European system is very similar, and I cannot speak to the Indian system, but that's something you should look into, and it probably has some similarities. There are 4 elements for tort to be claimed. One is a duty. So first there has to be a duty to the injured person. It can be shown that there was no duty by a developer of a company to that injured person because all the duty was to train the users. And that happens. That has come up in courts, whether or not there was actually a duty. So if there's no duty, there's no case. The next thing is a breach. There has to be a breach to this duty, and that's based largely on the concept of standard of care. What is the standard of care? And we'll go over that a little bit later. The next is to show actual damages occurred and causation, meaning that this breach resulted in the actual damages. And that's where we spoke a little bit about this difficulty in pinpointing and proving that the damages specifically occurred by this AI and why. Okay, so that is the big dilemma about the black box system and not being able to review it fully and get clear evidence on that damages. Sorry, there's one more thing I want to add in here. So let's see, I'm going to slide this up a little. Yes. So I think I mentioned this before, but I'm going to mention it again. It's very important. This concept of fault, which is based on negligence, versus strict liability, which is based on defects. Okay? Fault, you have to show that there was a fault, either in judgment, either in a deviation of the standard of care, to have a negligence claim. This is more difficult to accomplish because it adds this element of a fault having to be shown. When you go to strict liability, the reason they call it strict, and this is it was a little confusing to me at first because I thought strict, it it seems worse or something, but it's not. It really means that they only have to show that a defect was there. So it's actually a little worse for the manufacturer because they don't have to show fault, they just have to show the defect. So the burden of proof for going after a manufacturer on this strict or product liability is a little bit easier and more successful than this negligence idea because it leaves out this idea of fault. Then there's a concept of learned intermediary doctrine, or LID, you'll see in legal literature. It means that no matter what was going on with this machine, no matter what it did, no matter what it said, well, there is this intermediary called the doctor that is learned and should know better that if it makes some kind of glaring error, it's still the responsibility of the doctor to assess that. So this idea of learned intermediary doctrine, it basically means that you can't just say, I gave him that drug because the software said so. You know, that's not an adequate defense, right? I think I discussed this already. So yes, in defects, when you're trying to show defects in a device, in a product, there's either a design, and that would be that there's an inherent flaw in its original design that caused the harm. That's a defect, right? For example, if an implantable device was made with a material that was known prior to degrade prematurely, and that occurred and there was an injury and the high rate of fractures, that would be a defect. That's how a defect would be proven or pushed forward in the courts. Then there's a manufacturing defect, not in the design, but the manufacturing, and that's pretty obvious. You know, if this is a physical product, it was designed in a certain way, but then the manufacturing was defective. Now, in AI systems, this could be implied to connect to the training of the model, because the model may be designed by a manufacturer, but then it may be trained by another entity or another business entity or another legal entity. And this is another way in which a manufacturing defect could occur. And then it gets even more complicated because in some states and some jurisdictions, this could also be kicked up to a negligence situation where they should have known that they should have trained it better on a different model, and they were negligent in the process of doing it as well. So it gets very complicated, and the challenge is when the lawyers are to present to a court, they have to submit a complaint. And when they submit a complaint, they have to try to figure out what the best strategy is going to be. And it's unpredictable exactly how the court's going to see that. And once they submit this complaint, if they didn't select the proper strategy, taking all of these variables into account, the courts can dismiss a complaint on summary judgment, being that there wasn't enough evidence to proceed further down the line of a legal process, and then they really can't submit it again. I mean, it's, you can't be tried twice. There's a sort of double jeopardy concept. You can't be tried again because, okay, we're going to try another angle. Well, so the challenge comes with the fact that they have to carefully scrutinize the process through which they're going to try to reclaim damages. Now, another very important concept that comes up is failure to warn. And failure to warn is sort of like, this is very common with like drug-related complications. Let me just see what time, okay. So in failure to warn, the manufacturer may not have fully detailed some of the complications, and therefore the doctor in the package insert, which they're obligated to read according to law, may prescribe this drug and there's a complication. And if this complication was not really detailed well in the package insert, well, that may be considered a defect in the product rather than a negligence. So, and remember that going through defects is easier for the plaintiff than it is going through negligence. So this is an issue. Now, this also becomes a major issue when you're dealing with AIs about training models. So this failure to warn doesn't just apply to the moment that the product is released. It's an ongoing process that the vendor and the developer, they are obligated to update failure to warn warnings, right? I'm sorry, they're obligated to update the warnings. So even ongoing into the future, it's still possible to claim that there was a defect because the hospital or the end user were not properly warned of things that were figured out later, like the model was inaccurate and we have to retrain it with a model and update. So it puts a lot of burden. This strict liability concept of a defect puts more burden towards the developer. And the issue with that is that if you keep shifting the burden towards the developer, you're going to reduce the incentive for the development of AI products. And that's the concern with the general idea, is that if we disincentivize because of liability, that may not be a good thing. We may stifle development. Okay? So that's why this becomes very important. I'm going to move on a little bit further. And I think we've covered a lot. So I want to talk about this for a second, because we're at about 9:11. So I'm going to this, and then I'm going to go through a couple of things to wrap things up and get questions. So this is very important. This is, in the US particularly, the definition of the standard of care is a reasonably competent physician with the same training would provide this recommendation or care in the same or similar circumstances. Now, what this does is this requires the use of plaintiff and defense expert witnesses to define exactly what the standard of care was. And these are opinions. And in trials, these are weighed. The plaintiffs have their experts, and the defendants have their experts, and the court hears it, and they make a judgment basically of who they believe more. So it's actually a dynamic process. It's not a codified system. With AI, this adds a new element, because there have been cases that have been initially thrown out in court stating that the expert is not an AI programmer, he's a doctor. So how can he say that that was an error? And there's a particular case that I will get to, that this was shown as the initial flaw by the court, but then the Supreme Court reversed it and said, no, this doctor is able to speak to the fact that this other doctor listened to the AI even though it was wrong and should have known better. Okay? So these are the kinds of conflicts that are going to arise. Now, I want to get to some of the solutions. Here. So there have been some solutions. So the EU, back in 2017, proposed theoretical AI personhood, to claim that an AI was a person. And as a person, it could be held liable for negligence. But then the question is, well, who pays the AI's insurance? You know, how does the AI testify in court? Right? Those things are very problematic. So that suggestion, which has been floated by a number of legal scholars, eventually by the EU decided not to go down that road, because it was too complicated and included way too many new ideas and concepts. What they did instead is that the EU decided to apply strict liability, which is the product liability way, and that's the way where you just have to show a defect, and that's kind of more difficult situation for the developers because it's kind of easier to get cases against them. They applied that to high-risk AI systems, and they assigned healthcare AIs as high-risk systems. So in the EU, this was adopted in 2024. So it was, and it's not been implemented yet. So this is a very, very recent process in the EU. So in EU, AI healthcare systems are largely going to be viewed as high risk and going towards strict product liability rules, making it more difficult for the developers because it's easier to find defects when you don't have to also find fault. Then there's this concept of enterprise liability. That has been floated by a number of legal scholars in the US. And it's kind of going along the trend that we see happening in healthcare in US particularly, but also in most other parts of the world as well, where everybody becomes an employee. And if everybody's an employee of the enterprise being the hospital system, and it's a huge corporation, let them assume vicarious liability for everybody. And that would simplify the plaintiff recovery process because you're going to go after one single entity, the hospital. And the doctor, if they make a mistake, they're working for the hospital, they're an employee of the hospital's responsible for everything. Now in the US, there are cases that are brought against doctors, and almost always, or very often, they're also brought against the hospital. So if they're two separate cases against two separate plaintiffs, they can have two separate strategies. Okay, and that happens. Well, if we went towards an enterprise liability system, everything would be consolidated against the hospital. That may make another problem arise, which is the deep pocket phenomenon. So if it's just automatically assumed that the hospital or the large enterprise is responsible, it may be difficult to shield it from the deep pocket phenomenon, and judgments could be made of really outrageous sums of money, which is happening in the US, because they know that this is a multi-million, multi-billion-dollar corporation, so they're going to sue for huge amounts of money, and that may increase the cost of delivery of healthcare services because the premiums for the hospitals will go up, and then who's going to have to pay for that? Because that's going to work into the overhead of cost of providing healthcare. So that's the fear of that. The other is to just simply create a no-fault scheme, which means that no fault has to be found, no fault, but if it's determined that an injury was caused by the AI, it has to pay. End of story. This has a similar problem because, that fund could run out very quickly. So that's one scheme. And the last scheme is to come up with specialized AI liability specifically for the AI. So this AI, rather than treated as a person, is still covered by a specific liability insurance. It brings up the question of who pays that. Are you just shifting liability insurance payments, back and forth between different entities? So the last thing I want to talk about, and there are some very nice examples in the presentation about case examples. So you show the take-home message on that is that there's never been a single case yet in the US against an AI specifically. There have been some cases against software companies, there have been cases against robotics companies, but never specifically against an AI yet. But it will happen, okay? So that's what we're going to be tracking into the future. Now, in conclusion, what do I think is going to happen? I think that we will have to have localization of the systems so that they're actually tuned. Like, even if it's a vendor that sells it to Amrita, it's still going to have to be tuned to the population here. So we won't be able to just use any system, and that's going to make things a little more complicated. There's going to be upkeep, training, credentialing, and a lot of other things that are going to go into it, making this a little more expensive than it just seems to say, hey, we got this great AI product, let's just buy it, it'll help us. It's not going to be that simple, okay? The next thing is probably some move towards enterprise liability is going to gain traction. Why do I think that? Because I know that in the US, 20 years back, there were almost all private doctors working in hospitals, covered by their own insurance companies, and now the number of private doctors is very small. And if we keep going in that direction, eventually consolidating liability is probably going to end up being some solution. But in order to prevent the deep pockets phenomenon, we have to have some kind of reasonable caps put on even these enterprise liability claims, which has really not happened. In many states in the United States, they may have a cap if it's a medical negligence case, but if it gets turned into a general negligence case rather than a medical negligence case, there's no caps. So there have been cases where they first tried to do it as a medical negligence case, then it turns out into a general negligence, and that's worse for the vendor if that happens to them. And, you know, what's also going to happen is there's going to be privacy issues, especially when we're looking at the global regulatory divide, when we have some regions of the world that can easily obtain data, train models without any issues about privacy control, and then we have other regions of the world, more in the West, where there's very, very strict privacy laws that are going to prohibit access to data, which will make it more difficult to get accurate models, while these other populations may be able to very quickly get much more accurate models because of the lack of these privacy laws. And there's going to be some kind of interface between these two probabilities and systems. Also, these systems that may be trained to be very accurate in one area may have to be retrained in another area, and they may not really be possible because of these privacy laws. So we're going to have to rethink these privacy concerns. Now, in conclusion, when I looked at all of this put together, what I feel is that this is a relatively disruptive change, but it's not unprecedented because we've already seen increasing complexity in the way that we handle healthcare on a daily basis. We have, 20, 30 years ago, we didn't have all of the same types of databases, information available, and we're still going to end up doing the same thing because we're going to actually make the final decision. The conflict is going to come into sort of what we're being required by the hospitals to do, what we feel that we can do on our own, and these kinds of things are really going to be up to us as clinicians to sort of maintain control over so that they don't take control over us. But I also, in terms of the legal aspect, the tort system is not a strict codified set of rules. It's adaptive. Though a lot of authors are talking about how difficult this situation is, the truth is it's just going to be growing pains. I mean, the tort system is designed to adapt. It's just going to be really complicated and involve new experts and other types of factors and a lot of other discussion. So that's what I have for you. And in the PDF, I gave you a lot of case examples that occurred in the US that outline these possibilities. Thank you. Thank you.
Fantastic information. Just before we continue, raise hands, but there's some more information. I've just come to know that there's some seminar here at 9:30. I've come to know just 10 minutes ago. I didn't know this. So two things, not much time for discussion, and breakfast area is behind, not the. So with that, please.
Andrew,
yes.
Quick. The two things that you told that was very important was how you got the training data set from Massive.
Yeah.
There were two hospitals in the US which contributed to the training set.
Yeah.
And then you mentioned data localization. I've been part of this consortium for AI development since 2017.
Mm-hmm. Yeah.
So the basis of what we started was breast cancer and diabetes because it's uniform across the world. But then we started looking at oral cancer. We couldn't get the validation set validated because of discrepancies.
Mm-hmm.
Now,
Yeah.
the problem is, like you said, you can't import AI system from the West into India.
Right.
Probably for most cases you can, but for specific cases you can't. So what we realized over the last 10 years is that diagnostics is going to change.
Mm-hmm.
So we already have autoanalyzers and biochemistry which give you the normal values and tell you whether it's normal or abnormal. That has taken away a lot of the clinical documents that you need. And already in radiology for CT chest, that's happening as well.
Yeah.
They might not give you the diagnosis, but they can give you the findings through an automatic system. So what I'm trying to say is that I don't know if surgical therapy might change with AI, but medical therapies, you can go to ChatGPT.
Yeah.
ChatGPT will get you 100% on USMLE now.
Yeah.
That's the data that we have. So you can go to ChatGPT and get therapeutic data.
Yeah.
But I don't know from a surgical point of view whether it can replace the clinical judgment and the skill that the surgeon has. I'm not putting it on you, but if you put ChatGPT, your HbA1c and your random sugars and your fasting sugars, it will give you a treatment schedule. But I don't think it works in surgical therapies.
I think what you're saying is just actually reiterating what my final conclusion was, is that this is really not new, that we've been evolving the way in which we practice medicine with the addition of all of these digital tools for decades now. So this is just really one evolution in the process, albeit a little more complex, but we're well accustomed and prepared to do this. Yes.
So the question is about whether we need to adopt this AI or not. Okay. So my question is, can it boil down to an informed consent? Explaining you said that clinician is 95% accurate, and AI most probably maybe a little more like 98%.
Right.
So can this be explained to the patient who is going to ultimately adopt this? And if he takes that informed consent for yes, it will solve all these problems.
So this is also a very important issue, and it's also being looked at by medical ethicists. The real question is, you have, just like with all informed consents, I can tell you that, from all of the years that I've had some involvement in the legal system in the US, I cannot recall a single case where I reviewed where the informed consent was the magic bullet, so to speak, to make the case airtight. It's really assumed that the informed consent is more of a formality. And if you sit down with a patient, imagine the scenario. You're going to sit down with a patient and say, I'm going to give you this drug. The AI is telling me it's good. I'm not so sure. Would you like to sign a consent form for the AI recommendation or my recommendation? It sounds like a very obvious issue, but it's not so obvious. And this won't just be a single event. There are going to be AI-guided aspects of everything we do throughout the hospital stay or throughout the patient care. So will liability simply be protected by just having the patient signing their general informed consent? I also consent to any AI use in the hospital. Imagine if they say no. What are you going to do? But it won't be possible to not use it. That's eventually it will just be there. I don't think we really have a choice about adaptation. I think that adaptation will not be up to us. I think it's going to just happen. It's going to show up in all of our machines beyond our ability to control it. The adaptation is going to have to be on our part. Okay, thank you.
I think the next seminar, that's already started.
Thank you. Thank you very much.